Lara, what do you think of what the prosecutor did there?
Definitely, in my eyes, it's prosecutorial misconduct. I mean, she knew that it wasn't very clear what this man was saying. And I mean, it's really hard to believe, though, also, a man who knows he's being recorded to say something like that. She should have known better than that. And I agree. This is something that should have been brought up in a motion and eliminated before it came as evidence. Well, it wasn't even evidence. Before she asked the questions before the jury, they were highly prejudicial. I don't even see any relevance, honestly, especially that it's basically her testimony. Now the jury is actually seeing what a prosecutor is thinking, even though it's not really evidence, but it could leave an impact on them. It's pretty prejudicial information. Again, this should have never come in, not knowing what was going on and the context of it. It sounds like the defense attorneys tried to help here and maybe minimize the impact, but I'm sure they must have made a motion for mistrial at the time, and I'm guessing it wasn't granted.
Yeah, Andrew, what did you think, Andrew? You're state attorney. Yeah, I mean, you're the head of the whole office. What would you think if one of your attorneys did something like that in the courtroom? Is it fair? Andrew, your answer is probably fantastic, but we lost your audio. So hold that thought. We'll try. I feel so bad. All right. So another one of the issues in this case is that they are saying, and this is what, for this motion for a new trial, they're saying, listen, the attorney for Todd Mullis basically blew it by conceding that this was a homicide and not arguing the accident theory. So, Renee, how about that one? The accident theory. I mean, to me, this is a simple mathematical equation, this whole trial. 6 minus 4 equals murder. There are 6 puncture wounds. There's only 4 prongs on the corn rake. That's not an accident.
Yeah, well, with that, I must agree with you. That's certainly not an accident. Also, the fact that the son indicated that when he first observed her, she was on her knees, sort of on her knees facing down, and, the rake is in her back. So if she had fallen on it, she would be on her back. So the accident is not really going to fly, and obviously
it's
it didn't, because the jury came back and found him guilty.
Say it. It's ridiculous.
Vinny,
repeat after me.
It's
ridiculous.
Not a good argument. I agree with you, Vinny, which is very rare, but I agree with you.
There you go, folks. It's one small step. All right, Andrew, I believe we fixed the problem. So,
Sure.
Andrew, let's get back to the recording. Again, you're the head of the office. You run the. If one of your attorneys that works for you is trying a case and did something like that, would you have a problem with it?
No, not at all. A good buddy of mine from law school is from Iowa. This is Big Ten country, Hawkeye football, and they know a Hail Mary when they see one. And this is a Hail Mary. This is a desperate attempt by the defense to try to throw out a conviction. There's no real basis here for anything in terms of misconduct or any evidence that was improperly admitted. Look, we know what's going to happen tomorrow. This is a foregone conclusion. Based on everything that I've seen in the case and what I've read about it, they're going to deny the motion for a new trial. He's going to be sentenced. We know what the sentence is. Game over. He's going to prison for the rest of his life.
Lara, the other part of this argument, and I looked at those puncture wounds, they're not even lined up. It looks like someone was swinging this thing at her several times, unfortunately, as gruesome as that is. And to me, that's a sign of rage. The type of rage, Lara, that someone would have if you were paying a vendor thousands of dollars and he was sleeping with your wife and then lying to your face about it. And then this is the second time your wife has done it, and you've worked your whole life since you were a little kid to earn enough money to build a farm so you could be a hog farmer. This is big time stuff. This isn't Green Acres that this guy's running. This is a big time business that he built with his own sweat, and he's not going to give it up to some woman who's sleeping with the vendor who he's paying thousands of dollars to. That's what it sounds like to me.
I guess that's an argument that the prosecutor must have made, and that's one of the reasons they got this conviction in this case. But at the same time, as I was going through the evidence, I noticed that there were some issues with the timeline and his ability to get to where his wife is and to basically attack her the way she was attacked in this case, and get back to where he was before his son came back. My understanding is that his son testified that he only left his father's side twice, but for a very short time period, just to go get a drink of water. And the idea that he could run the length of a football field, get to his wife, kill her, come back, was a little, a tough sell. But clearly, the prosecution here was able to do it. And I think a lot of it had to do with exactly what you were just saying, Vinny, that hatred, the jealousy, the idea that he caught his wife cheating a second time and he was outraged and he didn't want to lose the business that they both started together. The motive itself was so strong that they decided to convict him, despite some of the issues that the defense had brought up.
Yeah, it was a compelling trial. Tomorrow will be a compelling day. It all begins at 1 o'clock. Live coverage from Iowa right here on your front row seat to justice. 1 o'clock tomorrow.